Good morning, everybody. Thank you for having me. I tend to move around, walk a little bit, so I might do that a little bit here. When I got the call, got the opportunity to speak, I was pretty excited because although I speak to a lot of groups, I actually get asked to speak to a lot of insurance and defense community-oriented groups, and it's fine, and I'm always the applicant's attorney offering their perspective. When I usually get early, kind of scour the crowd, make sure no one has big objects they want to throw at me. Once I spoke on a panel that was entitled How to Make Sure the Applicant Doesn't Hire an Attorney. Of course, well, that's what I do. It wasn't that hard, though, because I told them all the things that they need to do to make sure they don't hire an attorney, and then I concluded by telling them, you're still going to mess it up anyways, and they're probably going to call me. But in any event, when I have the opportunity to do these, especially with this kind of a size group, it's an awesome opportunity to learn. I'm excited to hear what Jody has to say, and I caught the end of Dr. Cacciarella's presentation. And I know we're going to have time for interaction and questions after lunch. So again, thanks for having me, and I'll be around through the end, and look forward to getting to know some of you. So over the next 20 to 30 minutes, let me tell you a little bit about, let me just rearrange. What's that?
You want to book in?
No, I'm totally good. I just have my outline here on the laptop. Perfect. I'm going to talk a little bit about apportionment. I'm going to talk a little bit about some myths of apportionment. I'm going to talk a little bit about substantial medical evidence and on sort of a timeline approach and why that's important for you and for all of us in the system. I'm going to talk about a couple of cases, one that deals with apportionment, another deals with impairment, Benson and Kite. Going to give you a couple updated case law analyses and talk to you sort of what's on the legislative horizon. I think I can get through most of that in about 30 minutes, and we'll revisit some of these topics and issues when we speak this afternoon. Let me just kind of share one other anecdote for you. The judges that your reports go in front of, that they have to determine support our settlements or our substantial medical evidence, they have conference once a year, a couple-day educational conference. And two judges came to me afterwards just on their own volition to tell me a little bit about the experience. And there were some leaders from the Division of Workers' Comp up in San Francisco that were present at the meeting also. And there was a significant discussion at the meeting this year, just a few months ago, about the frustration at the Workers' Comp Court from the judges about the medical reporting that are coming from medical legal evaluators. And this is on the heels of a report that just issued in the last few weeks where the state auditor did an audit of the QME system and identified a number of problems with how that system is being run by the Division of Workers' Comp. So we're kind of, and as you know, there are regulations percolating that will impact the fee schedule for med legal evaluators. So we're kind of at a time in the system where all of the focus is on this part of the process. And I can't per se predict where it's going to be 12 or 24 months, but there are two very important pieces to this process, well, three, that I hope we can, as a community, solve. One is physicians have to be paid fair and reasonable fees for work they do, especially in the medical legal arena. We ask you to solve our disputes. It has to be considered and thoughtful. And if you're not compensated, people are going to top sheet it, and we're not going to get the evidence we need to close the cases. That's not good for me. It's not good for my clients. It's not good for the insured. It's not good for the employer community. Number two, we need to have injured workers have access to QMEs. And in a lot of places in the state, the access doesn't exist. The lists aren't kept up properly by the Division of Workers' Comp, and we need to have some solutions in that. And the third one just escaped me, so when it pops back into my head, I will bring it to your attention. But those two are really important considerations in the process. Let's talk about apportionment for a minute. Let's see here. I usually talk about the myths of apportionment at the end after I've talked about apportionment itself. I'm going to do a little bit backwards today. And I really need audience participation. So everyone has a right hand. I'm going to ask you to hold it up. First of all, has everyone in the room been to a educational seminar about apportionment before? Right? Everyone. Okay. Most of you. Okay, great. Everyone in the room, would you agree that you must discuss apportionment in a medical legal report? Okay. Must there be a finding of non-industrial apportionment in every single medical legal report? Okay, right answer. is a determination that there is no, let's see if I can ask this in a Jeopardy way. This is really yes or no. It doesn't require participation. Is a determination that there is no non-industrial apportionment a valid apportionment determination? Yes. And we have language in the code that says if you can't make an apportionment determination, you need to refer to another physician to do so. That's oftentimes misinterpreted to mean that no apportionment means you have to send it out. That is not the case. Must a doctor's report reflect an accurate understanding of the principles of apportionment to be considered substantial medical evidence? Yes. A medical report that does not explain how and why. If you remember anything about a conversation about apportionment, anytime you discuss apportionment, you must say, did I explain how and why I came to my conclusion? If you do that, you're ahead of the game. So, a medical report that does not explain how and why it came to its apportionment determination can be relied upon by the court as substantial medical evidence. No, it cannot. Speculative apportionment determinations are acceptable as an approximate percentage of disability caused by other factors. No, cannot speculate. The defendant has the burden of proof in proving the other factors in support of non-industrial apportionment. That is correct. The WCJ or the WCAB shall give defendant further discovery rights and or develop the record to ensure that defendant meets their burden of proof on apportionment. No. The defendant has to solve that conundrum before we get to court and the judge answers makes the final determination. The irony of it all in that last point is that Escobedo, which is the seminal case, after the change in the law in 2004, which is where the how and why standard comes out, Miss Escobedo had injured herself. I think she worked at Walmart, if I remember correctly. And the WCAB was evaluating a new standard of apportionment and applied it to the facts without giving the parties the opportunity to actually develop the record to answer the question as to why the new standard should apply, which was really shocking and a little backwards. But in any event, it left us with the courts don't always get it right all the time either, actually. But it leaves us with our standard of how and why. So how has apportionment and apportionment issues developed since the Escobedo decision back in 2005, 2006, to where we are today, and what are some things that you need to consider? There was another seminal case in 2007 called Brody, and it's important to understand what Brody tells us about the definition of permanent disability. Permanent disability is understood as the irreversible residual of an injury. A permanent disability is one which causes impairment of earning capacity, impairment of the normal use of a member, or a competitive handicap in the open labor market. Thus, permanent disability payments are intended to compensate workers for both physical loss and loss of some of all of their future earning capacity. So let me just stop there and give you pointer number one on apportionment issues as it relates to me advocating for one of my clients. Yep. Did it fall?
Don't lift it, is what you say.
Want to put on my jacket? Okay. Thank you.
Making weird noises.
Better? Okay. No worries. It's good to be reminded that I'm being videoed because sometimes I say things my mom would not be proud of. When I get to Benson, I'll try to keep it G-rated. There is apportionment of disability that you commonly apply, but sometimes I need to ask you questions about work restrictions and how it affects somebody in the open labor market because there's other evidence that I'm trying to gather to help prove up a case. And apportionment of sort of old rule or old school work restrictions just might not seem all that important to you, but they are to me. And a common question is I might ask you to explain to me if the work restrictions the person now has, because you're still offering those for the return to work considerations, are those work restrictions such that they predated the injury? And generally, if they didn't predate it, that can be helpful to my client in trying to prove up how their injury impacts their ability to compete. The concept that, as I was listening to Dr. Cottrella and looking at some of her slides, and it's so difficult to grasp, is the distinction between the causation of injury and the causation of disability. Yes, risk factors are absolutely consideration in development of an injury. They may not always be substantial medical evidence that can be relied upon as the direct cause of permanent disability. In simpler terms, just because you have a risk factor doesn't make it an apportionable risk factor in every case, unless you can explain how and why that risk factor is directly causing that individual's, it's an individual analysis, permanent disability. It's a confusing concept because, frankly, it's a legal concept that is not rooted in any scientific medical theory. And as practitioners of medicine, where you come from is scientific background. So it just butt heads, and it's really challenging and it's difficult. And it isn't scientific, because I could have 5 doctors look at the same 5 facts and they would all give me a different opinion on apportionment. I'm going to talk a little more about injury and disability in a minute, but let me just back up and explain why. How many of you in here have actually seen what I call a permanent disability rating chart, where it lists the percentages and the money that's worth to the injured worker or the money that the employer or insurer has to pay? Has anyone in the room seen that? Okay, a couple of you. So why is apportionment and permanent disability important? Money. You'll be interested to know that money paid for indemnity for permanent disability in workers' comp is the smallest amount of financial exposure in the workers' compensation arena. Temporary disability indemnity is higher. Medical treatment costs substantially higher. UR and IMR costs higher. And medical treatment the highest. What also arose out of the reforms back in 2004, and it's applicable to both apportionment and permanent disability analysis, is accuracy. We need an accurate rating, and that's where the Alvarez-Guzman cases emphasize, and it's actually incorporated in the law in 2013, that the parties are to identify and find, through their reporting physicians, accurate permanent disability. The money matters. When a physician just willy-nilly says, there's 2 injuries, it's 50-50, that makes a big difference to the recovery to the injured worker and the savings to the employer. On that same scale, the higher we go up the scale, the more money the person gets paid. 1% is worth 3 weeks of permanent disability paid at $290 a week. That's the maximum permanent disability rate. If you had an earnings of $200,000 a year, you can't go back to that job until your percentage of permanent disability is paid out. You get $290 a week, tax-free. That's the cap. So if you're 10% disabled, it's worth about $10,000. If you're 20% disabled, it's worth about $24,000. And it goes up a little bit because the weeks expand, but the rate is the same. And the exposure in these cases changes at 70%. Because at 70%, the injured worker gets something around $100,000, $120,000 in that range, depending on the schedule. But after that, they get another payment called a life pension payment, which pays them a small sum for the rest of their lives. That life pension payment at 70% starts around $80 a week. And if you are 99% disabled, it can go as high as about $260 a week. And that particular benefit is adjusted by cost of living. So what does that just tell you about all of this? My clients are not in the system to get rich, which is a misperception. They're in the system and they get this additional benefit because that's what the law affords. And in return, the employers can't get sued for civil damages. That's the break that they get. That is the benefit of the bargain. So, and we're going to talk about depositions a little bit later with Jody, but when I send you a letter or one of my colleagues comes in to question you, we're not there to be a real pain in your rear. We really aren't. We're just trying to get to the accuracy of it and maximize the benefits as the law allows. And there are things about the law that I like and things I don't. I'm going to talk more about that in Benson in a minute. 4 points to consider when evaluating causation of disability and causation of injury. This is the route that we go. We define the injury, your diagnoses. We determine the cause of the injury. It could be multifactorial. We define the disability from the injury. From your perspective, that's primarily doing an analysis under it is the analysis of the AMA guides, because that's what the law mandates, the 5th edition. And then you have to determine the direct cause of that permanent disability. The statute, if you haven't reread 4663 in a little while, let me just read it, because the words, every time I read it, it kind of hits me in the face. A physician shall make, that's why everyone has to make it, an apportionment determination by finding what approximate percentage of the permanent disability was the direct result of the injury arising out of and occurring in the course of employment, and what approximate percentage was caused by other factors both before and subsequent to the industrial injury. So the word direct is a really, really important term of art. If something is indirect, then it's not a basis for the direct cause of the disability. Did they get the practice tip that I emailed you? Has that been circulated or no? Do you know?
To everybody in the room, no.
Okay, so fine. I'm using a practice tip that I helped write for CA earlier this year, and afterwards, yes.
Would you like me to circulate it to everyone afterwards?
Yeah, that's fine. If we have it, that'd be great. It'll be circulated. There are two examples in here, and I'll just share one of them. And you can read the other at your leisure, and I'll move on. Here's an example. A 60-year-old woman with significant osteoporosis. She trips and falls while at work, breaking her femur. So the injury is a fractured femur. There's only one cause of the injury in this example. That's the trip and fall, which applied significant force to the bones, causing them to fracture. So in other words, applicant could have continued on with her osteoporosis without suffering any fracture. And maybe it would have fractured for some other reason, but we don't know that. That'd be speculative. So while the osteoporosis may have made applicant more susceptible to the bone fracture, that fact is immaterial to the analysis of causation of injury. The trip and fall is the proximate cause of the injury itself. The definition of disability in this particular case, her residual disability was a limb length discrepancy, about a 2% whole person impairment. And that was based on how the fracture healed. In this particular example, I would argue, I believe the law supports it, that if you look only to the disability and what caused that disability, it's the leg-limb discrepancy, which was directly caused by the fracture itself and its resulting healing. Tough concept. That's how I think the law would still maintain it at the present time. Talking about risk factors for a minute, they're tough, especially in the internal medicine arena. They come up in heart cases a lot. The law, I believe at the present time, even though I may not like it because I would prefer that the employer take my clients as they find them, but I do believe the law does support apportionment for risk factors in a situation where you can explain how and why that risk factor is directly causing the disability in that person. And I think when you look at apportionment analyses with risk factors or other injuries, as some of the examples Dr. Cottrella provided at the end of her presentation, I like to look at these issues on a timeline manner. When my client comes in to see me, I'm trying to see how remote, how recent the symptoms, the condition, the risk factor is. If I have someone who smoked for 6 months 35 years ago, and they now have a pulmonary problem from exposures of work, and they were at work for 6 months or 16 years, these are all factors to think about. And I think the longer the person's at work and the longer they have exposure to the continuous trauma exposure, that probably leans more heavily to work being more the predominant cause than maybe some other apportionable factor that can be substantiated. I do a presentation on occasion with former Judge Ray Corio, who updates quite regularly an apportionment outline. And he loves to put in the outline every year cases where the court just sent the judge's decision back because the doctors didn't explain how they came to their apportionment conclusions. And he's always famished. He's always worked up over it whenever we speak. He says, I cannot believe it. We're 14 years past the change in the law in Escobedo, and they still can't write a report and tell me how they came to their conclusions. So the how and the why is key. And looking at the factors on a timeline, I think, is a very big deal. Also, when you're looking at past medical history, I don't believe the judges are persuaded by the fact that someone may have had a history or problem in the past without contemporaneous medical records documenting what was going on. If my client says, well, I don't really remember getting treatment to my elbow, and the records show there was treatment to the elbow and residual problems, the judge is going to not believe what my client has to say. So the not that the records are always right, but they are really, really, really important. And I raise this because if they don't exist in a case, it's hard to speculate as to what the apportionment is or give great weight to a history without medical documentation. Sometimes you don't have it. Sometimes they didn't do a diagnostic test that you would have liked to have had 20 years ago. But that's just the law. So what about the law would frustrate you and frustrate me, or all of us in the community, is I like to use this analogy. It's not the best analogy because I call it the workers' compensation playground, and because for the people involved, especially my clients, usually the connotation with the playground is you go somewhere to have fun, and being in workers' comp isn't necessarily fun. But the one thing I appreciate about the playground analogy is that there are rules on the playground, right? And you go to the playground, you know when it's open, how tall you have to be to ride on the ride, what you can do and what you can't do, what you can bring and what you can't bring into the playground. If you're a physician and you don't like a particular way the guides tells you to rate something, or you don't like this apportionment rule, it's not enough to just say, well, I don't like it, I'm going to do it a different way. Those are the rules, you got to play by those rules. When it comes to the Benson case, this is a particular case that when I go into the playground drives me completely bonkers and nuts, and I cannot stand it. I think it's the stupidest case ever decided in workers' comp in my 20 plus years participating. But it is a part of the rule of the playground, so I must understand the rule and play by it. Let's change gears and talk about Benson for a minute. How many of you have read the Benson case? Don't be shy. Okay, about a quarter of you. How many of you have had to address a Benson issue in a medical legal report? Okay, about half. Okay. Can anybody, in one word, tell me why the Benson issue is important to the employer and to the injured worker?
Just in one word?
One word. Oh, wait, exactly. Whoever said it. Money is right. It's a money issue. So if we had more time, I could explain to you the entire background as to how we got to the Benson rule. And it is, from a legal point of view, kind of fascinating, but we don't have the time, and it might be more fascinating to me than to you. But Benson is stupid because of the following. First, let me explain to you the rule. The Benson rule says that a reporting physician, if there are more than one injury directly causing the industrial permanent disability. I have a sheriff. He's injured in January and in July of the same year to his back, both in altercations with a suspect. Okay? If the doctor believes that those injuries are both directly causing his residual, final, permanent, accurate disability, the doctor under Benson shall make an apportionment determination between the two injuries. But there's an exception, and the exception is important. In a rare and limited circumstance, that's what the case says, where a doctor can't do that, then the doctor can indicate that he cannot medically parcel out the permanent disability between the two injuries, and the injured worker gets a combined award. Now, you've heard the phrase, if you waded in this pool, inextricably intertwined. So that's not in the case anywhere except in a footnote. The term is actually medically parcel out. You can use them somewhat interchangeably because everyone in the community and the judges understand it to be the same, but accurately it's medically parcel out. So let's pretend that my sheriff ended up having a 2-level fusion and the report rates 50%, which entitles him to $75,000 approximately, okay? $80,000. Let's make it 80, make it easy. And the doctor says, well, he had 2 injuries, so I'm going to apportion 50% to the first and 50% to the second. Well, problem number one with that, the doctor didn't explain how and why. That'll never fly. It's not my burden. It's Jody's burden. I just gave her the best tip. She knew that anyways. I'm kidding. She knew that was her burden. In fact, I walked up to her and shook her hand and said, hey, apportionment's your burden. But if the doctor explains it, and let's say there is some evidence between the first injury and the second injury that the doctor can rely upon, an MRI, clinical findings, and the doctor somehow, some way can explain why it should be 50-50. On that scale that I told you about, instead of getting $80,000, my client might get $60,000. So how does this make sense? How in a public policy does it make sense that my sheriff, who's out protecting the community, should get $20,000 less because he had 2 injuries for the same employer, when he has a colleague, his partner, who had 1 injury and gets the $80,000, had the same exact injury with the same exact surgery? That's why the case is absolutely bonkers stupid. It makes no sense. Why does the employer bear the burden of that savings?
How would that work inside? This same police officer was assaulted by these 2 individuals. Is somebody say 50 and 50? He gets nothing?
No, he would just get, no, that's a good question because you're talking about predominant cause. The courts have held that predominant cause can be met by multiple injuries, so it would not impact their right to get it, but he would get less money because it would be split up on the money, okay? So what do you as the physician do with that problem that I've just raised? I get frustrated when I'm deposing a doctor and they have played by the rules and they've rightfully explained the Benson and I just don't like it, but I'm stuck with it. So my last question is, do you think that's really fair? And they always tell me it's not fair. That isn't your obligation here, is to make a determination really as to what's fair. You have to do what the law mandates you do, and that's analyze the evidence. And my position to you is that it isn't always easy to split them up. And it isn't always easy to explain how and why. Where you can, I don't like it, but you got to do it. Understand the impact of it. There are a number of reported cases where the court has upheld the Benson exception. And it's usually in situations where the injuries are pretty close in time and there really isn't a lot of medical evidence distinguished between the two. Here's just a couple of considerations that I look at when I'm looking at a case on this issue. Did the second injury prevent the first injury from healing properly, in part maybe because they were close in time or the person was still undergoing active medical treatment between the first and the second? Maybe there wasn't diagnostic testing to really delineate between the first and the second. In those cases, it might be hard to split them up. The first injury has actually rendered that injured part of body sufficiently weak or more sensitive to the second incident, and has just contributed to the damage in such a way that you really can't justify splitting it up. Although it's not required under the current analysis that the timing of the multiple industrial injuries become permanent and stationary at the same time, I think that's a consideration. I mean, if one was clearly permanent stationary 2 years earlier and it was never really sort of unpermanent stationary or un-MMI, and the person has a new injury to the same part of body, then there may be evidence there to support splitting it up. But if you have 2 injuries close in time and they really all kind of come stable at the same time, and now you're trying to figure out the direct cause of the permanent disability, I think the fact that they kind of reach their maximum medical point at the same time is something to consider. A couple other considerations. If the first injury really is just very insignificant, yes, to the same part of body, yeah, it happened, but you really believe that there's evidence that the direct cause of the disability was all due to the mechanism of, say, the second injury, you can say, yeah, there were 2 injuries. It doesn't mean that there has to be apportionment of permanent disability on both. In some cases, I have people who have multiple kind of minor specific trauma, and in the end, the doctor really looks at it and says, that's part and parcel of their employment. I really don't see, those were micro traumas. To me, it's the bigger picture of a continuous trauma here. So I don't really have to address Benson on multiple specifics. To me, this is identifiable and best told and best described as one long continuous trauma. So those are some things to consider in that analysis. 2 last points from me. Case law, let's talk about that for a minute. I saw it on your slides, Dr. Cottrell, and you left it for me, so thank you. There was a case from February of this year, Gary Mills versus American Medical Response. It's just another example of how the Benson exception applied. In that court, the WCJ found that the applicant was entitled to an unapportioned award of 100% permanent disability, even though the injured worker had 4 separate specific injuries and a cumulative trauma injury during his long employment as a paramedic. And in that case, actually, although the orthopedic examiner was able to apportion between the multiple industrial permanent disabilities, the internal medicine physician was not able to. They didn't have the evidence to be able to explain how and why they could. So That just leads to highlights another point in an apportionment situation. You get to make in your specialty your own determination. You're not bound by, if you're the psychiatrist, you're not bound by the orthopedist. If you're the orthopedist, you're not bound by the internist. In fact, if you're the internist and you say, I just follow the apportionment of the orthopedist, your report is not substantial evidence. Now, you could follow the orthopedist. That is certainly an option if you can explain it. But it's not mandated, and it's not enough to just say, I follow the other doctor's conclusions. So in this case, the internist had his own analysis, or I think it was a he, and the court upheld it. The legislative horizon. We have a new governor last year, and there wasn't anything too terribly earth-shattering in the work comp arena that the governor weighed in on with respect to the issues we're here to talk about today. But there is a bill pending, what we call a 2-year bill. Our legislative session is 2 years. And this bill started out in the Assembly and is parked in the Senate at the moment. It was rewritten on the way to the Senate. In its current language, it won't be its final language. I'm 100% sure of that. Now, whether it turns into language that ultimately gets through both houses and on the governor's desk, I don't know. But you want to keep an eye out for it. It's Senate Bill 731. And the premise behind the bill was to address the following problem. Current law requires a physician who prepares a report addressing the issue of permanent disability due to an industrial injury to address the cause of the permanent disability in the report, including what approximate percentage of the permanent disability was caused by other factors, before and after the injury. We know that. We just spent some time talking about it. This bill would prohibit consideration of race, religious creed, color, national origin, age, gender, marital status, sex, sexual identity, sexual orientation, or genetic characteristics to determine the approximate percentage of the permanent disability caused by other factors. There's been some cases that have tried to, and succeeded in some instances, talking about genetic predisposition as a basis for apportionment. There have been other cases that have shot that down. This bill is important for a couple reasons. One, if we have clarity as to what can be apportioned to and what can't, we'll cut back on litigation, make your jobs easier, and life will move on. The other reason why this is important is because there is nowhere in employment law, anywhere else in California, where you can treat somebody differently based on all of these characteristics, except workers' comp. It's ridiculous. As an advocate, I think it is. That's the pitch to the governor. That's the pitch to the legislature. We should treat similarly situated employees the same, whether it be in the work comp setting or any other employment setting. Whether that bill actually makes it to the governor's desk, your guess is as good as mine. But I do think it's an important public policy discussion that needs to be had as to how California is going to treat its injured workers related to these immutable characteristics.